All right, guys, welcome to the May 2022 PRC meeting. We have a couple of regrets. Stefan can't make it, and Peter can't make it. Peter's in Australia visiting family, so good for him. Actually, for the purposes of taking minutes, Brendan has stepped in to take Peter's place. So thanks, Brendan. Really appreciate it. Thank you very much. Okay, so first item of business is approval of the agenda. So can I have a motion to approve the agenda, please? Howard, and then we'll say seconded by John. All in favor? Wonderful, thank you. We have the minutes prepared by Peter for our meeting of April the 12th. They're comprehensive as always. So again, can I have a mover? Matthew, a seconder. Howard, all in favor? Thank you very much. Okay, so news and announcements and updates, what have you. Item number 4 on the agenda. Do we have any news that we want to bring to the committee's attention? Always a good idea to look back on the weekly criminal justice updates that Howard prepares. Anything from those minutes, Howard, that you want to share?
It's funny and perhaps a curse that there's always interesting things going on in criminal justice, but the only thing I'd point out is the Supreme Court of Canada decision released quite recently on the Jordan trial delay issue. The interesting part of this one is it's in the context of a retrial ordered on appeal. So the question is when the clock starts ticking on that. There was considerable delay in the first trial, but that it was never argued in the first trial or in the appeal of the first trial. So anyway, have a look at, I think it's interesting.
Yeah, thanks. And this reminds me, there was also a really interesting Supreme Court decision with respect to access to counsel, the right to counsel. So a gentleman was detained by the police. He talked to his counsel. He understood that his counsel was going to be attending, actually physically attending, to provide him with counsel in person with the police. The police denied him the right to see his counsel, and the counsel actually showed up at the police station. And as a function of that, the court found a violation of the right to counsel because it's a continuing right, and clearly the police had violated his full right in that regard. So that was an interesting decision as well.
I can raise an issue with Howard, since Howard keeps better tabs on these matters than I. You, of course, are aware of the reaction to the finding that 50% of women convicts in the federal system are First Nations. And there was, among some proposals, there was a recommendation that there be a deputy commissioner for Indigenous inmates. Howard, the commissioner, Kelly, you probably know her better than I do, is said that she's open to the possibility. I'm not sure what that means. I'm wondering what the scuttlebutt might be in Ottawa, Howard.
Matthew, I saw exactly what you're talking about. And of course, the 50% figure comes from Ivan Zinger, the correctional investigator, but it's not a surprise. These numbers have been increasing, particularly with respect to Indigenous women in Indigenous institutions. But I wonder if we might call on our friend and colleague Irving, who has a much closer relationship with CSC and the commissioner. I saw that as well. The recommendation has been around for a long time. I think back to the date of our Boer's report. If I'm not mistaken. But Irving, can we convince you to chime in at all on that?
I was going to say no comment. Yeah, no, it's yeah. I think our board recommended it, and the reality is just by increasing names or titles in the bureaucracy doesn't change anything in terms of intake to correctional institutions. I mean, that's the reality of it. If we're talking about population, CSC doesn't control who comes in. They do control the kinds of programs and preparation of individuals so they get on parole on time and so forth and so on. But You know, there was a recommendation years ago to have a deputy commissioner for women. They did that. I'm not sure that changed anything in particular. And this one has been hanging around for a long time. I think our board recommended a deputy commissioner for women. I don't remember where the deputy commissioner for indigenous people came from, but it's been around for a long time. I think Howard Sapers brought it up many years ago. That's probably the origin of it. Frankly, I don't see how that's going to change anything. There's a lot more that needs to be done in communities and social programs, educational programs, and all kinds of basic kinds of things. It's not going to change because there's one more person on the totem pole. Pardon the reference to indigenous issues there, but I mean that's what it is basically. It's a facile kind of recommendation that Ivan and Howard probably thought is going to looks good on paper, but it's not going to change one iota. We've seen the numbers go up for Aboriginal peoples in the correctional system. It's like doubled since I looked at it like 10 years ago, just as an example, in terms of women and in terms of men as well. But it's frightening if 50% are of the women offenders in CSE's facilities are Indigenous. It's frightening.
Thank you, Uri. Thanks, Matthew Howard. All right, let's move on to item 5, business arising. So we'll look at the parliamentary committees. The first one is Commons, Justice, and Human Rights. So that's Howard.
Thanks. I just had to check to see whether my mute was off or on, but thanks, Miles. Yep, I'm going to try and make this brief. The Justice and Human Rights Committee has met 4 times since our last PRC meeting. All 4 meetings scheduled on Bill C5. I note from the agenda, Miles has indicated we'll deal with Bill C5 later down on the agenda, so I won't go into the content or the substance there. I want to note that there are 2 other meetings scheduled as of now for the committee's review of C5. One this afternoon on May the 10th, obviously, and the next one for Friday, May the 13th. Some of the witnesses who have appeared, they've been getting a lot of good witnesses. So I'll just give you a smattering of them. The African Nova Scotia Justice Institute, the Canadian Bar Association, Mothers Against Drunk Driving, the National Coalition Against Contraband Tobacco, the Canadian Association of Black Lawyers, the HIV Legal Network. They gave some very interesting testimony. Just again, running down through a smattering of them. The association, pardon my poor French pronunciation, Francois, but the Association des Services de Réhabilitation Sociale de Québec appeared. Others are the Canadian Association of Chiefs of Police, the National Police Federation. Just in terms of what's coming up, Criminal Lawyers Association will appear, the Federation of Asian Canadian Lawyers, the Six Nations Police Service. Friday will be an interesting one if you're inclined to watch it, because there is the Aboriginal Legal Services. Jonathan Rudin is always interesting to watch. The Canadian Association of Elizabeth Fry Societies, and our friends at John Howard will be appearing this Friday. So have a look at that. One of the things just that's particularly important to note is at its meeting of May the 3rd, the committee decided 2 things of importance. They decided, one, that the deadline for the submission of amendments to the clerk of the committee, so these would be amendments brought by members of the committee, by parliamentarians. The deadline for that is this Friday, May the 13th, and they've indicated that the committee will commence clause by clause consideration of the bill on Tuesday, May the 17th. Now, that's important because the clause by clause review, as you will know, is where they go clause by clause and vote, starting with the title. Amendments are introduced and either voted down or accepted. So that's when they get to the crux of the matter, and that will start a week from today on May the 17th. So we'll see sort of what comes out after that. But I think I'll stop there unless there are any questions.
Comments, questions? We're good? Thanks, Howard. All right, let's move to the Commons, Public Safety and National Security. And Rob is here with us.
Yes, thanks, Miles. There's a bit of an echo in this room. Are you guys able to hear me?
Yeah, you're good.
All right.
Yep.
Okay, good. So the committee met 4 times. they're quite focused on the rise of ideologically motivated extremism in Canada. So 3 of the 4 times were in relation to that. A lot of talk of social media contribution towards that. Loss of confidence in institutions by citizens. Social media kind of acting as an accelerator of views and problems, around those issues. So not a lot there for us at the moment. We have also the 4th meeting was regarding the assessment of Canada's security posture in relation to Russia. And that was on May 3rd, no evidence available on that, and possibly not much for us either. The one item that I did note that was had some relevance was the report presented to the House on April 25th, a path forward reducing gun and gang violence in Canada. There were 34 recommendations in that report covering a variety of areas. They did ask the government to table a comprehensive response. So that will be something I'll keep my eye out for. For 34 recommendations, just briefly covered a variety of areas. Like I said, improving data collection and information sharing, improving firearms tracing, helping people exit gangs, serious crimes should equal serious penalties, decriminalizing illicit drug possession, prevention of firearms smuggling and strengthening border surveillance, firearms importation and sales, and firearms licensing. And in one spot in particular, toward the end, I noticed that this is kind of a bit of a sort of a learning for me. I know they submitted a report, and near the end, they have recommendations as a committee, and then it seems that the I guess non-majority parties or other parties sort of can submit their own, put their own 2 cents at the end. So the Conservatives have a letter, sort of a note at the end, the Conservative kind of members of the committee, I assume, the bloc, and as well the NDP. So the just quickly summarizing what they had to say. So this is at the end of the report, putting their 2 cents in. So Conservative ones got wanting the government to recommending the government revoke the gun buyback program and the proposed provincial handgun ban, and reallocating that money to target anti-gun smuggling operations, police services, and programs targeting youth. As well, that the government withdraw Bill C5, which is sort of squarely in opposition to what we're have been working, what some folks on the committee here and others have been working on regarding mandatory minimums. So the bloc, they were mainly wanting to reword some of the recommendations to sort of strengthen them in their eyes, I guess you could say, implementing as soon as possible the gun buyback program. So adding that kind of language to one of the recommendations, and wanting to they want to have the authority to ban handguns. So the NDP simply kind of, they sort of stayed had a general kind of tone to their comments, basically conveying to move away from prohibition and punishment and instead adopt a national harm reduction approach. So that's my summary of the report that was presented. And again, not much for I guess went on at the actual meetings for me to share with you today. So
Thanks, Rob.
Thank you very much.
Very good, thank you. Any questions or comments? Okay, we'll move to the Senate. So firstly, it's the Legal and Constitutional Affairs Committee, and we have Brendan for that.
Hi, everybody. So since our last meeting, the committee has only met a single time on April 27th to discuss Bill S4. And sorry, I should have asked this immediately. Can everybody hear me properly? I know there's been issues in the past. Thank you. As I was saying, they've only met once on April 27th. The committee is due to meet again tomorrow, as well as Friday of this week to continue discussing Bill S4. At this time, the witnesses at the first hearing, sorry, let me clarify. Bill S4, for those who are perhaps less familiar with it, it's an act to amend the criminal code and the Identification of Criminals Act and to make related amendments to other acts, parentheses, COVID-19 response and other measures. Largely, it is an attempt to expand the use of remote technologies for individuals to appear in court, for police to obtain telewarrants in different ways. So it's essentially expanding the use of technologies in courts, ostensibly to increase efficiency in the criminal justice system, as well as to increase access. So in this first meeting, the Justice Minister appeared along with some members of the Department of Justice to explain the bill, how it might work. One thing, a lot of the senators had questions about the actual practical implications of these provisions in the law, the proposed bill, I should say, and most were pretty unequivocal that the expansion of these technologies would obviously not be particularly helpful for rural and remote litigants who have difficulty using or having access to internet and other technologies like that. A lot of the questions from the senators revolved around access to justice issues. But the general feeling in the committee is that most are quite in favor of the bill, that it can help, but there is some reticence or some hesitation that it may not help the way that it is expected. I would note also that I believe one senator brought this up, but despite the fact the Justice Minister and the sponsoring senator brought up the fact that this bill might increase efficiency in the in criminal courts, that has not really been a topic of conversation in the committee. That is basically what happened in the first meeting. Like I said, not a whole lot of substance. There appears to be a great deal of agreement on the bill. So yeah, even the critic on the bill admitted to the Justice Minister that despite being the critic, he's rather supportive of it. And I think I will leave it there for that meeting, because I know S4 is also on our list of bills to look at later. So I believe I'll leave it there unless anybody has questions for me.
Questions, comments? Thanks, Brendan.
Thank you.
Okay, thank you. All right, lastly, the Senate, the Human Rights Committee, that's mine. So at last meeting, I just simply advised that they had met one time to simply agree that they would examine any issues dealing with human rights generally as they came forward. And since then, they've had actually 3 meetings, April 25th, May 2nd, and May 9th. What they're doing is they're calling witnesses to talk about forced and coerced sterilization of persons in Canada. So that's a topic that they've brought to their own attention, from what I could tell. It's not as much a criminal justice issue as it is obviously human rights, although there is a criminal aspect to it in that a forced sterilization would certainly be a criminal offense. Lacking consent would be an assault. Or that's not the road they're going down right now. They're just simply going down the road of hearing from witnesses who believe that they've been a victim of that particular practice. So that's about it, in that it's not criminal justice. But if they come up with a report for next meeting, I'll certainly bring it to everyone's attention. Okay, questions, comments? Thanks, everyone. Okay, so moving on, again, Business Rising, items B, C, D, and E. There has been no change that I know of. The only one that I would refer to is the confinement reform report for the justice report that Andrea is working on. I don't think that's been published yet. I haven't seen it. Has anybody seen it? So it's not yet out there. Item 5F is the invitation letter for the consultation on facial recognition guidance. And the way we left this was that Peter and Lynn were preparing a final draft for review, and Lynn's with us. So Lynn, can you update us on that issue?
Hi, thank you. I understand that our colleague Peter is probably in Australia now, I hope, visiting his child. And when we spoke, he had updated the draft and was going to send it along, but I'm not sure if he was able to, I imagine that he was able to take the comments from the committee and amalgamate them with the latest draft. But I'm sorry, I'm not able to give a more fulsome review because I was out of the mix for the last spell on account of my father passing away. So thank you.
Oh, sorry for your loss. Yeah, certainly. Thank you very much. So we'll return to this when Peter is back with us next month. He is in Australia visiting his daughter and grandchildren. All right. The next item is G, invitation to participate in the national consultation on human trafficking. John had worked on this for us. I don't know if you have anything to add to. Right now, it's looking at it as a waiting brief. Is there anything to add to that, John?
Nope.
Nope. Okay, fair enough.
Other than it's been submitted and yep.
All right, thank you very much. All right. Item H, the alternatives to incarceration. This is the ongoing matter that's within the purview of both Matthew and Kyle. Is there anything to update on that report?
No, but I finished all my grading, so including the stragglers that drive all of us professors nuts. Be that as it may, I'm going to be devoting my attention to this draft.
All right, thank you. So I'll keep it on the agenda exactly as it shows now. So next month we'll return to the prospect of a draft letter from yourself and from Kyle. Okay, items I and J, there is no change, which brings us to new business, which I don't think we had. We reflected on this at the beginning of the meeting. So let's go to the bills. So that brings us to the government bills and the commons, and we're back to Howard with Bill C5 and all the work, the tremendous amount of work that he and Brendan and whoever else has been involved in the last month. So Howard, take it away.
Always looking for that unmute button. No, thank you, Miles. I don't have a lot to say about this. This was a good collaborative project. Brendan was completely indispensable to it. My two pro bono student Canada students, the term has ended, so our CCJ's relationship with them has concluded, but yesterday I sent them the version of the brief as it was sent to the parliamentary committees, both Senate, House, and the ministers last week. The two students, Claire Whitty and Naomi Nadir, I think she pronounces as Nadir, were wonderful working on this, and I think they found it interesting. And so I hope I've asked them to take some pride in the finished product. I think the recommendations speak for themselves. I believe there's a lot of good analysis in there, including content about equity considerations. We're all pretty much aware of the extent of over-incarceration of Indigenous peoples. We had a reference a few minutes ago to Indigenous women in particular, but also racialized individuals as well. It's interesting, the position in our brief is quite similar to what the CBA has said. Before the committee, there are other people who would go further, some including repeal of all MMPs other than murder. Usually people qualified by that. There are a couple of witnesses before the parliamentary committee who actually said instead of worrying about diversion for possession offenses under the Controlled Drugs and Substances Act, we should simply repeal possession offenses. That is, decriminalize or legalize possession of small quantities of all drugs for personal use. You will know that that's something the Trudeau government has set its mind against, has clearly said it will not do. It has no intentions of going beyond the legalization of possession of marijuana for personal use. So the recommendations will probably fall on deaf ears, but the diversion provisions wouldn't be necessary. The diversion provisions in Bill C5 are focused entirely on the possession of drugs offenses, and they wouldn't have any particular need or meaning if possession of small quantities of all drugs for personal use was legalized. One of the other things you may not have seen is in the brief, we made a reference to the principles that were enacted or proposed in C5 to be enacted in the Controlled Drugs and Substances Act about the use of drugs and it being a health issue. I think those principles are very good. I mean, we lauded them in the brief. I was very pleased to see them. I wish they would take those principles more seriously and go further. One of the witnesses before the parliamentary committee said, well, no, you shouldn't be talking about drug possession and addiction and use as a health issue. You should be talking about it as a human rights issue, because a lot of people use drugs without untoward effect. So anyway, the witnesses before the parliamentary committee, including several police organizations, were opposed to this going much further. The Mothers Against Drunk Driving don't want the conditional sentence made available for impaired driving causing death and refusal, the related refusal event in that context. So the committee is receiving a lot of testimony on all sides of the issue, so they hopefully can get a balanced perspective. I personally believe that the brief we put together with some great help from Irving and from Peter gave us good comments. He and I went back and forth a couple of times, and from Andrea and from others, including members of the board, were very helpful. Irving, just remind me, you had staff send that off to ministers and committees last week, or?
Sent it off on the 28th. It's
okay, good.
Almost a week and a half ago. Yeah.
I don't think there's any difference between the copy of the brief that you have that Miles included, dated the 27th, and the one went off the 28th. There's a different file name, but otherwise I think they're the same. Is that true, Irving?
I suspect, I mean, I haven't compared one with the other, but I assume we sent the last version of.
Okay. So that's about all I'd want to say. But let me just add Brendan again, whose contribution was substantial to this brief, if he'd like to jump in and share a few comments.
I think you have it pretty well covered there, Howard. Thank you again, thank you for always sharing credit. It's very appreciated. But I think you covered everything there. It was a wonderful experience, and it was a pleasure to write that with you and the other students involved and all the other members of the board and the PRC.
Just a question for Howard, if I can have one. Howard, what, and maybe Irving can chime in, what is the logistics now of our status on appearances, either on the Senate side or the House side, or are we not going to make an appearance at all?
I'll turn it over to Irving in a second, but my understanding is this. Well, I know for sure the letter that went off to the committee said that we would be willing, or they should call on us, feel free to call on us to come and give testimony. One of the reasons why we were trying to move this quickly and to the end of April is to get it to the committee, the Justice and Human Rights Committee, before they started clause by clause. And we have done that. They haven't contacted us to appear as a witness today or this Friday. And again, next Tuesday, they will go to clause by clause, but they do have the brief so that they can review it and have a sense of it. Matthew, you will recall that during the Harper eras, I think CCJ only appeared once at committee, and it was at the invitation of an opposition member, not the conservative government. I've appeared a couple of times with various members of the PRC or staff in the Trudeau era, but we haven't appeared frequently. But I think we always do ask, or at least indicate to the committees that we would be willing to. The only thing I'd add to that is my own experience is it's always more pleasant to appear before the committee in the Senate, and we sent off the brief to them as well. They may invite us to attend. It's a much more civil experience where they actually listen to what you have to say. But I've said a lot. Irving, do you want to jump in on that?
There's not much to add. As you've indicated, Matthew, In our covering note, we always tell them we're prepared to testify if they invite us. It's up to them to invite us. Format-wise, I am not sure how it would go. It's kind of late, I think, for the Parliamentary Committee or the House of Commons Committee. If the Senate invites us, I'm guessing it might be virtual as well. I think they're doing a lot of their stuff through Zoom or whatever, but irrelevant. If we get an invite, then somebody will definitely attend and give an overview of the brief and answer any questions they may have. And I presume the easiest would be for Howard, is the most knowledgeable in the area, and he did most of it on this particular file. So we'll see. If we're invited, we attend. If we're not invited, well, we say thank you anyway.
I vote we send
Irving-
Brendan.
Irving, if I can, if I recall, my tenure with the PRC goes back to the early 90s.
Yeah.
In the day, as a secretary of the committee, we often would send somebody up to Parliament Hill, and if we weren't testifying, we were there, sometimes schmoozing with the chairs and various individuals who we got to know on the committee in terms of
Right.
commentary. Do we do that anymore, or no?
We
don't?
haven't done that. I mean, you're talking about some, a process or a way we managed 30 years ago where CCJ had a lot more staff and there were a lot more folks who were involved in Ottawa. John Braithwaite used to attend, and I can't remember the fellow who used to attend very frequently. He was the father of a parole officer. Does that ring a bell? And Matthew, you're on mute. The name will come to me later, but it's been a long time, Matthew. It's probably close
Yeah,
to
he was the father of a young female halfway house worker who was murdered.
That's right, in the halfway house on a weekend.
A day parolee. Weren't you the regional?
I was not responsible, Matthew.
No, I'm not saying that you were. I'm not saying.
No, I'm
that.
just kidding.
Saying, but weren't you the regional commissioner?
No, it was before my time. This was
Is that Rygrock?
Rygrock.
That was
Cecilia Rygrock was the victim, and her father was
Jerry Rygrock.
a top-notch guy.
Yeah. No, that was, I was in Ottawa at the time. I was not in Kingston. It would have been very, very early in the 90s or late 80s.
Matthew, even if we had time, the COVID has kind of affected the amount of schmoozing we could do
Yeah.
right now. But the availability of these hearings virtually allows one to watch them and view them, whether in real time or after. I mean, I go back. I've appeared before both parliamentary committees more times than I care to admit. But these days, everything is changing. The people are changing. The clerks, the researchers are changing. There's not a lot of people. I find it interesting that Rob Moore is co-chair of the Justice Committee and Human Rights. He used to be one of the Reform Party, real hang 'em high kinds of guys, I think. And anyway, I mean, I think getting these briefs to the committees in a timely fashion is essential, which is not always easy to do because everyone's so busy. But the other thing we've done lately, Matthew, and I think it's a good practice, is we make sure we send it to the responsible federal ministers. In this case for C5, justice and public safety, but also health. There are two health ministers, one for addiction, who is an associate health minister, but CDSA comes partly under the Federal Ministry of Health. So we know that the committees are pretty well controlled and whipped, even in a minority government. There's a lot of good testimony, but the reports don't usually reflect all of that. I have to believe getting our views in a timely way to the ministers, federal ministers responsible for the legislation, particularly because we were urging them to consider going further. And a lot of witnesses at the committee have stated that they ought to go further, which helps supports our view. But I think getting it to the decision makers in the departments is also a good step that we've done pretty regularly over the last little while.
All right. Any other questions or comments on Bill C5? I just want to point out, and it's very impressive that, with Howard's coordination, to actually get this from the PRC out to everybody to have comments received, to have those comments incorporated into the final draft, and then to get it into the hands of the relevant parties for the discussion on a clause by clause basis. So congratulations, that's a real achievement. Very nicely done.
Thank you. Irving is a big part of that,
I'm sure. No, I mean, we were talking, yeah, there's a number of people who are involved, including people who put the comments into it as well. So very well done. Thank you very much. Okay, moving on to other bills. And to tell you the truth, there has been very little activity since our last meeting on government and private bills. So in the Commons, the only change, as in moving from one committee to the next, was the introduction of Bill C-270. It's an act to amend the criminal code dealing with pornographic material. And it prohibits a person, the enactment is intended to prohibit a person from making, distributing, or advertising pornographic material for commercial purposes without having first ascertained that at the time the material was made, each person whose image is depicted was 18 years of age or over and gave their express consent. So that's a private member's bill. It's had its first reading on April the 28th. I should ask, does anyone want to take this up, follow it, prepare a brief? Okay, well, we'll leave it at that. So that's it for the Commons, and in the Senate, no new government bills. Brendan's already referred to what's happening with Bill S4. It's had its second reading second reading March 31st, and it's in committee, so there's nothing to add to what Brendan had to say. And there are no changes to any other Senate bills, government or private. So unbelievably enough, we're early.
Actually, Miles.
Yes, Brendan.
I'm sorry. Can I just say one thing about S4?
You sure can.
So in regards to S4, I think I told the PRC last month that I had met with the representative of Senator Kerrigan to discuss S4. I was in the process of working on a brief that's taken a bit of a back burner. It's a little on the back burner at the moment, just because when I was working on C5 for a little while with Howard and his other students. But I would also mention that another reason I haven't been moving as far forward on the S4 brief is because I'm actually testifying alongside Cheryl Webster on this bill as a PhD student. So I've sort of started putting my ideas into my own testimony rather than the bill. So I just want to sort of give that update that that's sort of where I am. I'm not opposed to finishing the brief, but it's just the S4 has seemed to move along more quickly than I had anticipated. So I haven't had as much time to put the brief together.
Well, good for you, Brendan. Yes, Howard.
So Brendan, just to be clear, is your testimony with Cheryl on the Senate on S4?
Yes.
Good. She's fabulous. She's done a lot of work. She's a great criminologist. For those of you who don't know her, she's done a lot of work on justice efficiencies and procedural issues. And I told Brendan I would volunteer to help him on S4 because of the criminal procedure parts of it. But like Brendan, we're both kind of running full out to try and catch up with all of the things going on in our lives. But Brendan, I would encourage you to do both of them. I think actually whatever your submissions are with Cheryl, maybe we could look at those as the basis for a brief. I think so highly of Cheryl. Anyway, I just wanted to throw that in there for people.
Sure.
So a question to Miles and Howard and Brendan. Is it your advice that the association have a position on C4?
S4?
Yeah. Personally, if I can answer, and perhaps if I've missed anything or if I misspeak, please somebody let me know. But I personally think it would be a good idea. If I can maybe just briefly say what my personal thoughts are of the bill is that I believe it's a worthwhile bill. It's a bill that may potentially help some people and give flexibility to the courts. However, I think a lot of what they're permitting is already in practice. So the bill is, I don't think, harmful, but there are certain issues or there are certain aspects of it that may not translate well in practice. And there are concerns about how this bill is being presented as sort of a panacea to court delay, when in reality it likely won't. So generally, it's a good bill, can be helpful, but let's not expect it to solve court delay, and let's not expect it to provide the same type of access to justice to all litigants. And I think that might be an important caveat, is that the differential impacts that this bill might have on certain people. And that's why I think it's important to have a say on S4 if we are able to.
Thanks, Brendan. Howard?
Just to add to that, Matthew, as you know, there have been so few government bills on criminal justice that in terms of the PRC, it's slim pickings in terms of what we want to chime in on. But this bill is offered as a response to delay, and is an attempt to use procedural, particularly technological means to help deal with delay. But I think, and Brendan's more familiar with the bill than I am at this point, but I think it's fair to say that like many of this government's criminal justice bills, they're tiny steps offered as panaceas when they're not. It's a small step forward that, as Brendan says, largely has been practically put into a use. Again, they're little steps. Not that we don't want to encourage them to do it, but we want to encourage them to be a little bit bolder. They also seem to lack appreciation of the fact that it cuts unevenly across the system. Brendan's main point, we've talked about it briefly. I may be mischaracterizing it as saying your main point, but there are whole groups of people who are missed out by this. So rural individuals, people in the extreme parts of our country in the north, there are vast expanse in the country. If you don't have access to high-speed internet, if you aren't familiar with technology, not everyone in Canada has a personal computer. So there are all sorts of limitations that don't seem to be recognized, and I think they're worth pointing out. We often at the PRC, at least in my recollection, we do kind of a draft brief and then see if the PRC wants to take it on or not. But I think S4 is worth doing. It's just there's a lot on. I know that there's some criminal defense lawyers, one particularly high-profile one in Ottawa, who's very much opposed to S5 because it disadvantages some of his clients, and it creates a kind of procedural issue. And I can't speak to it because I'm not familiar enough, but I know that I think there will be some defense counsel speaking against it in the sense that it's an attempt by the federal government to push things through. Those of you who have white hair like me will remember Eddie Greenspan when he was still alive saying, "I don't have to have a computer. I have a quill pen and I use this pen. You give me disclosure in hard copy. I do not. You cannot force me to use a computer." Those days, I think, are long gone. But there are people who do not have access to computers and hence not equal access to things. And that's a particular issue. So Matthew, I'd be interested in your views, but I think Brendan's right that it's worth opining on. The question is whether we can get something together and how quickly. But Matthew, does that help?
Well, yes, it's always very interesting. You know, I am not a guy that is a big proponent of justice efficiency, because I think by design, and maybe John is smiling, Winterdick is smiling at me, by design, the system is purposefully inefficient. In other words, the components all work at cross purposes and et cetera. So efficiency approaches to me are a waste of time. I would rather see decriminalization and the removal of jurisdiction. And we have 52 prisons operated by the federal government. Can we close a few of those crazy places? I mean, that's the direction I would go in.
Thanks, Matthew. I don't want to stretch anybody too thin, but for the purpose of the agenda, can I put down that a draft brief is being worked on by Brendan and/or Howard? Okay, that's great. So both of you, that's great. Thank you.
And we should deputize Cheryl Webster as well.
Yeah. Okay. All right. Before we adjourn, actually, just a couple of quick things. Brendan, can you please record in the regrets? Sean, it just came to my mind that he did send me an email quite a while ago, so I want him to be shown in the
Yep.
minutes that regard. Andrea joined us after we flew over the issue of her upcoming article in the Justice Report. Andrea, do you have any idea when that may be published?
Sorry. It's supposed to come out in the May edition. So the big mega edition that's coming up this month. I guess it is already May.
Okay, well, thank you. So we'll hopefully read it and reflect on it at our next meeting. Super. Thanks, Andrea. All right, everybody. Anything else for the good of the committee? We did well today. All right, so thank you. Our next meeting is the 14th of June, which I suspect is the last meeting before the summer break. So I look forward to seeing everybody then. So take care. And
Take care. Have a good day.
Thanks, everybody. Take care.
Bye now.
Bye now.